Welcome to another workshop in the community workshop series from the Debating Central, the Global Speech and Debate Council, DWA, and Orisho Podium. Today, we are going to be dealing with the topic Law for and in Debates by Kaushik Das, which is none other than myself, facilitating this session. So, you would be wondering why this workshop is relevant and why we are talking about this topic, right? I think there's one fundamental reason why this particular topic is very essential to be dealing with in terms of a conversation around debating. One, because there's a lot of relevance of law in terms of different types of motions and in how also certain motions directly or specifically utilize law in some degree, shape, or form. But also that law has a lot of relevance and counterintuitive pushes which come around in policy debates and models and in other frameworks and understanding how the society operates, which would directly then lead to you building better arguments and arguments which are more like logically coherent in the general gist of things becoming better for you when you're doing law. So law is very like particular in terms of how it operates, and law is also like very segmented in terms of how it is approached as well. There are different segments of law. That's not something that you're going to be seeing in this workshop. Rather, this workshop is only going to be covering certain legal principles and certain things around how law operates in the world and how things are going to be beneficial towards that extent in terms of your framing of arguments and in terms of how you are thinking about arguments in a preparatory time or elsewhere. So law does matter in debates for some reason that I already mentioned to you, that it does have a fabric in terms of the policy mechanisms, but it also is a very essential piece of the four pillars of democracy in a sense that it does interplay a lot with, say, executive, judiciary, media, and so on and so forth. So in this workshop, we are primarily going to be dealing with what is law in debates and what is law for debates in terms of how we'll be engaging with legal principles and specifically addressing motions about law. So, law for debates is essentially going to be covering, say, legal principles and frameworks which are used as tools to build and analyze arguments in any debate that you're doing. And law in debates will sort of specifically address motions that are specifically adherent to the theme of law, legal systems, or legal reform. So let's just directly dive in. The ubiquity of law is very important in terms of considering how the legal system is operating and what are the essential parameters around issues or challenges that the law system has, right? So there are many societal issues that have a legal dimension or implications to it, apart from, say, the policy fabric and other things that I was mentioning before. But law also is very reflective of social values, power structures, and also the way in which it is used to regulate behavior. Because at the tenet, I think the law is sort of meant to have certain rules and regulations in the society where people have signed like a if you are going to talk about it from the view of the social contract theory, where people have agreed to follow a set of rules and principles so that their livelihoods is better and they can live in a communal space. But understanding law also like helps you become better at analyzing what kind of problems or fabrics do society exist with, but also gives you a lot more analytical depth, and the sophistication of your arguments also increases in terms of how you're giving these particular like structures or talking about these particular ideas. So debaters can like utilize these frameworks like justice, rights, and responsibilities of different individuals within legal systems, as also how the legal systems has certain protections and mechanisms associated with it to evaluate policy and give clear criteria as to how policies will operate in a world and how there might be certain issues or non like starters in terms of the debate, in terms of people trying to make ridiculous claims or other issues being pointed out, right? So it often like gives you like very clear cut mechanisms as to how to compare different impacts in your debate space and different arguments in your debate space, because you have a clear cut clarity into how these particular spaces are operating and going to be beneficial to you in terms of how they're going to be molding different ideas, molding different principal structures, and molding different like pervasive like idea sets that are going to go up ahead and impact people in your model and impact people in general. So you can also utilize this as an idea to just define, justify, and critique certain things that the opposition has said, or maybe robust to increase the robustness of your arguments and your points in the way that you're debating. So diving down into the legal concepts, therefore, the first key legal principle that we are going to be talking about today is the principle of rights. So rights are a couple of different, like rights have a couple of different aspects or nuances associated with it. The first thing that we'll talk about is human rights. So what human rights is basically around is that human rights are inherently universal. So they provide life, liberty, dignity, and have certain principles or aspects in terms of that having like a basic formulation of what you are expected to have like, as a protection in a society that you're living in, or a community that you're living in. So there are like inherent concepts. You can address these concepts such as like the right to life, the right to liberty, the right to dignity, which are essentially present to you because of the virtue of you being a human and because of a virtue of you living in a democratic society or a democratic framework. Secondly, civil rights are those which are granted by the states themselves. So, for example, there might be in certain states the right to free speech, the right to assembly, where you can have protest when you are doing it in the legitimate means, and then there's a right to free trial in certain countries or fair trial in certain countries as well. So, civil rights are those that are then guaranteed by the state, or they're inherently not like a basic framework of rights that you would assume that a human is born with or born into, but rather something which is an excess which is provided by the state through like its authority and through its like power in terms of how people have agreed to live within that particular social structure. The third or fourth aspects are sort of like talking about how the state conducts their actions or regulates itself in terms of the narrative. So the first thing that is these on these two ambits is positive rights. So positive rights are essentially those rights which give like a positive virtue towards the community in terms of like giving some positive functions or positive methods or positive like infrastructure or something, so on and so forth, which will give you some amount of like benefit which is coming or accrued from the state, which the state is taking as an action. Some examples of these could be the right to education or the right to healthcare, where in some communities you might be given free education, in some communities you might be given free healthcare, or the government has established certain places where there are schools established through the government aid, or there are healthcare institutions established through the government aid, where there are cheaper alternatives for education and healthcare available in certain states. Each state operates very differently on the nuances of positive rights. For example, there might be, again, from carrying on from civil rights, there might be some states which guarantee educational rights or not. There might be some states which guarantee healthcare rights or not. Some might give you certain degree of healthcare that people under the poverty line possibly might get access to free healthcare or free education. People above the poverty line do not need so, and therefore they will not be provided. So each state has it within its ambit to like define what kind or what degree do these positive rights work within and work around. And that is something which is very like nuanced in terms of how you're analyzing these rights operating in a particular state. The second aspect of these are negative rights. So this is just the antithetical to say positive rights. It's something that the state is refraining from doing. So which is why you are guaranteed some like protections and mechanisms. So this might be something as simple as freedom for interference, where people are not like interfered by the state's operation, or there might not be like overarching or overbearing nature of the state bearing down on simple individuals so that their rights cannot be violated or like vitiated in any sense or form. So in these particular ideas, right, of rights and of how principles operate in this society, you can use these to frame the harms, benefits, and moral obligations in the debate space. So, what I simply mean is that you can analyze certain things which are coming as a problem when you're giving things like, not giving things like right to education, right to healthcare, or maybe there are certain benefits of giving a right to education or right to healthcare. There might be moral obligations on states, like that they might be morally obliged to give you the right to life, protect your dignity, protect your ideas of liberty, and protect the way that you're operating within the state machine. This can include like media freedom, press freedom, and so on and so forth, and also the right to like say things, right to speech, and there are other rights also which are granted in terms of civil rights. So in debate spaces, you essentially debate around the idea of how these rights are operability. First, operability of these rights in terms of the paradigm of the state, but secondly, also how these rights are necessary and institutionally correct to have appended in terms of the government structure, or on the contrary, why these rights are something which are problematic or create a burden in terms of how the society is operating, right? So there are, of course, two ways in which you can flip this. Now, let's move on to the next one then. The next one is the legal principles of justice. So here again, there are three types that you need to possibly look into. First is distributive justice. So distributive justice essentially means that there's a fairer allocation of resources, which is like divided up fairly amongst say different institutional requirements. There are different like benefits or burdens which come around from justice systems, and there is also a fair allocation of the same. Some ideas of these could be taxation, welfare policies, and there might be some things around, say, the society which is operating on the requirement of allocation of resources towards people who are more in need of them. For example, let's just take the idea of food stamps, right? Food stamps are possibly only going to be given to people who do not have like the income necessity which is required for you to sustain life in a state. So these food stamps are critically only like fair for those individuals who do not have the ability to do so. And the more that you give it to people who have, say, already resources or benefits, they are like taking away from having, say, benefits given to people who are more in need of the same, and therefore it becomes a problem. So distributive justice sort of like talks about in those issues as well, that you're only allocating resources fairly in terms of how their burdens are. In the idea of taxation as well, for example, people who have a lower income should be made to like pay a lower amount of income tax, for example, and people who have a higher income should be like possibly made to pay higher level of income tax because they are able to afford it better in terms of how they're operating. So that's the idea of distributive justice. Secondly, when we are talking about retributive justice, which is that fair and proportionate punishment is given to wrongdoers. So, for example, when you are like a criminal in a state and you've taken some bad actions or some bad like problems have existed within you as an operable member of the society, there are certain ways in which you are like going to be punished in terms of disrupting the societal behavior and the societal peace by, say, being punished for doing wrong. This wrong can be something like being a thief. This wrong can be something like committing an assault. This can be something like committing murder or something, so on and so forth. This idea of retributive justice also, however, is not just that you punish somebody who deserves the punishment, but you also punish somebody fairly. So what this essentially means is that somebody who's stealing something should not be given the same punishment as somebody who's probably murdering something just because of the degree of harm that they've done to the, say, society that they're operating within, and how much like critically problematic in terms of the moral burden has that wrong been, in terms of how they are also like accepted in society or viewed in society. So murder is of course viewed much more morally like egregious than, say, things like stealing some amount of money, and people have like different associated value systems about obligations, and through how things operate. So it's something which is very necessary for you to understand in terms of how it's working. Now, the last part of, say, justice mechanisms here is procedural justice. So, procedural justice means that there's fairness in process and decision making systems. So, for example, there are administrative decisions that you're taking, for example, land allocation, land grabbing, and all the other problems that are associated with it. Or maybe court procedures like allocation of cases, problems in terms of how things are operating, and so on and so forth. All of these should not just like look to be fair, but are actually required to be fair in terms of how they're operating and how the decisions are taken. You can't really like go beyond the bounds of rules in terms of applying certain principles and certain frameworks of law, or certain frameworks and principles of administrative justice in terms of how they're dealing with administrative issues. For example, if somebody is like approaching a court for a restitution matter in terms of like having the ability to get some amount of injunction or some uh, relief from a problem that they're facing, it's much more likely that it's beneficial for the state to operate in the idea of fairness, that they're given a time or a place in the court procedure where they are given the injunction quickly, so that cases are heard quickly, even if there are pendency of cases, and the priority of that cases should be like allocated accordingly. Similarly, if you're looking at places like, say, an administrative office, for example, there's a decision making system. People should not be like made to wait a lot without any due reason. Of course, administrative burdens and administrative challenges do occur, but you should also like appear to be fair and principally just when you're trying to like take forward administrative action for certain institutions or mechanisms. You can't make people wait for example, in India, if you're filing an RTI, you can't make them go round and round just to get a response from the RTI. If you're like, for example, in India, going to the registry office to register certain land deeds, it's not relevant, it's not fair or procedurally just to have, say, people not giving you, say, the chance of doing this particular action properly in the particular registry office that you're attending. This also deals with the ideas of like corruption, because of course you're not doing fairness in, say, processes if you're like engaging in corruption or morally corrupt practices. So that can also be something which is under highlight in terms of how we are addressing these three parameters. Now, in debate frameworks, these ideas is essentially used to evaluate the fairness and equity of policies and address different like narratives that are associated with the ideas of how states operate and states are required to operate within different frameworks and critical institutions. So the next particular principle then comes around to the rule of law. The rule of law is the idea that everybody, including the government, is subject to and accountable under the law. So the law sets out certain rules and procedures, like laws are clear, they state publicly what is supposed to be the rule. They are very stable and applied evenly to everybody, which means that it's very predictable as to how you're supposed to operate under the ambit of law, and which limits the like unchecked use of power and unchecked abuse of power as well, which can be like likely in terms of states becoming like corrupt or other principally problematic things occurring in the state. So in the debate sense, this particular principle of rule of law is used to like give arbitrary actions a call out mechanisms, or force like lack of accountability to be something which is center stage and then dealt with properly within the legal mechanisms, but also to justify that there are everybody who is under the ambit of the law is like a legal citizen, or in terms of like even say state machinery, like the politicians and other people who are elected leaders or representatives are all under the ambit of the law and therefore required to follow what the law states and what the law does. So it's very important for considerations. Now, the next idea that we'll sort of be talking about is due process and natural justice. So, due process and natural justice are, say, similar to certain civil rights or rights that we were talking about previously. So, the right to a fair hearing before one's rights are affected is, say, what is included within due process and natural justice, which includes the procedure that you're following through with court. So stipulations are that there are certain legal methodologies that you can like follow through when you're doing certain things around, say, adjudging guilt or adjudging some cases, or there are certain things that you really should be following through when you're say talking about aspects around the framework of law, right? So you can only arrest people at certain ways, like there might be a warrant requirement, there might be certain procedural limitation that you can't really hold somebody in jail for a long period of time, so on and so forth. There are natural ways in which rules and laws set out procedures where you can say adjudicate fairly on legal problems, but also say address issues in contraventional to law while providing like mechanisms to like prevent harm and so on and so forth. So due process simply maintains this particular opportunity by giving certain frameworks, rights, and principles which are like to be followed within the framework of law. Natural justice, on the other hand, is also not something far fetched from this particular principle. So, natural justice is this idea that justice should be not like only seen to be done, but also like should be done. So, it includes principles like having fair adjudication in a legal system, like a court of law, and there might be like confirmation that the impartiality of the decision maker is maintained. So all of these things come under the principles of natural justice. So under the debate framework, both of these ideas are simply used to like critique unfair procedures or prevent a lack of safeguards which are present, so that people can like live within a rule of law and a society with the rule of law present, and therefore also operate within the ambits of the law, so on and so forth. So it's very critical that you analyze what kind of necessities that you have within these structures, and that all governments have some sort of like differences in due process, of course, because not all states have like the same amount of like methods in which they are adjudicating guilt. They don't have the same legal recourses for like same types of cases. So those differences and those matters are something that you need to be careful in terms of distinguishing different principles and different ideas and moving on, so on and so forth. Now, in say the next legal principles, we will talk about proportionality. So proportionality is the idea that any measure that you are taking should be like proportionate to the aim that you are supposed to pursue. So you can't really be going offhand and becoming something which is overbearing or overarching over the need that is required in that situation. So you can ask yourself simple questions here. Are the means appropriate and necessary to achieve the ends that are envisioned? Are negative impacts outweighed by benefits? So these questions can showcase when measures are excessive or ineffective policies are in operation. What this inherently does for you is in a debate, sometimes some teams will like to frame their ideas around, say, having call outs or mechanisms where they will assume there's a lot more benefit towards the systems. But on a comparative scale, there might be sometimes excessiveness towards the required end goal that that motion or that principle or policy that they're trying to run might want, or there might be ineffectiveness towards their application. So that is where this entire idea comes around, and where we sort of can question the principally negated factors about how proportionality is important, or maybe proportionality is not being maintained in, say, the setting that has been run by one of the teams. So you can use it in the debate framework accordingly. The next principle is precedent or stare decisis. So stare decisis means that current decisions can set examples or standards for future actions. Again, this is not for all legal jurisdictions. Some jurisdictions do not have this concept of precedent or stare decisis. They are directly applying the law as in how it reads, instead of going around looking at, say, past cases and past examples of the application of the law towards the current decision making fabrics. So what precedent in the simplest term could be understood to be is the idea that if you're making a current decision, or if you're making, say, certain like actions currently in terms of adjudicating on a provision of law and giving certain amount of like analysis and certain amount of decisions around it, it is to be said that there are certain standards which that sets for the future, which might of course change. There might be certain requirement for change, and it happens also in certain countries. For example, in India, constitutional benches sometimes do override previous constitutional bench cases, when the quorum is supposed to be higher than the previous constitutional cases bench in and of itself, right? So there might be certain things which might be beneficial for you from this idea, which can be used to, say, for example, argue long-term consequences or challenges of certain things. So, for example, a measure that you might be arguing for, a policy measure or something, might be good for a framework for a short term, but if its consistent application or long-term consequences are bad, there might be fundamentally problematic things associated with it, which is something that needs to be cared about, which is what this precedent idea or legal principle of precedent sort of like looks like in debate settings. Now, the next aspect of sovereignty, or how sovereignty deals with in terms of the legal consequences. So, sovereignty is basically the idea that a state's supreme legal authority, or states a supreme legal authority within its territory, and has been independent from external legal impositions, unless like they themselves consent to it via their signatures towards certain treaties, or their ratifications or acceptance of certain treaties which are operating internationally or across, say, borders. So, what sovereignty does for you in terms of a debate setting is essentially this idea of jurisdiction. So, can you like really adjudicate on a case or not? What kind of responsibilities does the state have? What are the limits of, say, international intervention in certain actions taken by other states? What are the ways in which states interact with each other because of how they are in terms of sovereignty, and in terms of, say, their inability to go ahead and interfere in other states' actions, so on and so forth. So these are some like ideas in which you can base your framing as well in terms of how you're making your policy work. This is very important in terms of certain themes. So criminal justice systems, international frameworks, international institutions, international economics, all of these things have sort of like ventures into, say, the idea of sovereignty, because you'll have to see how international institutions are working within these frameworks to assess certain rights or liberties, and how it can or cannot interfere in other states, and to what extent it can. So that amount of criticality and that amount of thought process does go around where these things apply. So let's just go on to applying these legal principles and take certain like motions as examples. So the first motion, this house would implement a universal basic income. So there are a lot of things that you can consider here, right? So is it something which is distributive? So for example, as we mentioned, is it something that is going to be affecting the people who need it better than people who do not need it? Or is it something which is going to be morally correct to be done or not? So is it something which is going to give a positive right? So for example, the standard of living improving, which is somewhat a state responsibility. What are the potential impacts on property rights? What are the potential impacts on taxation? So on and so forth. So there are a lot of legal ideas that you can consider within the framework of this motion, right? This isn't really like a motion about law per se. So this is something like this is like an economics motion, but has like an idea of law which is associated with it, because as I was mentioning at the start, law is a critical factor towards a lot of policy mechanisms, and also mechanisms in how states operate with or without certain like direct like relativity towards a law being discussed or not in the debate space. So you have some amount of like requirements to understand how law helps you do better in terms of debating. So in the second motion, let's just quickly go through this as well. This house supports mass surveillance for national security. So there are a lot of considerations here as well. So this might be something which is a policy requirement, where you might be seeing what kind of instances of national security problems are running in the state, what kind of matters are there. So there are certain considerations here as well from the framework of law, which might be something simply around the ideas of the right to privacy, which is a negative right associated. Is it something which is proportional or not in terms of how your national security concern is being addressed? Is it like something which is possibly going to help you, like mass surveillance? Is it like justifying the ends of the ends or the means to that end, and also for how these particular people are then assessed critically in the framework of law and legal systems? The third thing that you can possibly look at here is how, say, process works or due process works for people who are facing mass surveillance, because people will have potential problems in terms of how they are being adjudicated unfairly. Sometimes there might be like a totalitarian state where there might be problems of authoritarian rules and authoritarian principles applying towards the rule of law in terms of how they're operating. And lastly, you can, and these are some examples only. So in this last example, if you're considering aspects like the rule of law, there might be a potential for abuse. Like people might like use these mass surveillance systems for benefit which is going beyond what is given under the purview of law. For example, you might not have a warrant, but you might be looking at somebody, tracking them through the mass surveillance system when you don't really have the legal right to do so. There might also be other problems that might crop up, that in terms of, say, the national security dialogue, you might take this by making this a political tool and make this assail other people in terms of societal norms and societal ways in which it is like harming other individuals. For example, it might harm independent journalism. It might harm people calling out the state because they are then assessed critically, even when there is no requirement to do so, or maybe by law or the stipulation of law, you're not supposed to be doing the same. So these kind of harms do accrue, and that's something that you need to consider when you're looking at motions like this as well. And I think that more or less gives you an idea about how you are operating within legal paradigms, in terms of different types of motions and how motions are like helpful or not helpful for you in that sense. So in this second segment, we'll be discussing law in debates, which specifically deals with aspects of how law is utilized for like creating debate motions and how different debate motions specifically from under the framework of law, right? So the first thing that we'll be discussing under this ambit is the idea about what happens when the motion is about law for the first instance. So when the motion is about law, there are different types of legal motions, right? Firstly, there might be some reformative motions. So they might be trying to reform specific laws, which might be like this house would decriminalize illicit drug use, or maybe this house supports the abolition of the death penalty. So this very clearly reads like this, right? That there is already um, illicit drug use, and currently in the fabric of society, illicit drug use is something which is criminalized. And the change that is sought out here is that the decriminalization of this activity is done. In the second motion, similarly, there is already a framework of law which is existing, like the death penalty is already there in certain states. What the motion wants to happen here is reform that aspect of providing the death penalty to certain individuals by abolishing it from like the totality of law in different states. So there are different ways in which these can operate. So there might be certain other specific legal motions which might look at like reforming or changing the ambit of what the law is or what the law dictates at that point of time. Secondly, there might be certain changing legal procedure systems. So, for example, we have talked about restorative justice. We've talked about different principles of law, right? So, an example of, say, a change in legal procedure might be this house would introduce restorative justice as the primary model for juvenile offenses. So, currently, it is not so, and it wants to implement the procedure of restorative justice. Similarly, in the second example as well, this house would abolish juries and complex fraud trials. We do know that certain countries have like juries, so there might be certain problems in terms of allocating juries towards complex fraud trials because people might not have specific knowledge, and there might be people who take advantage of those situations, and there might be problematic considerations of the same. So what essentially happens then is that these discussions then systematically move around changing certain principles or procedures in how the legal system is operating, um, which is like only a procedural thing rather than like a law completely being negated or abolished towards that extent. Thirdly, international law is the other consideration, which is that there are certain international institutions and international frameworks under which you operate. So that can also come under the ambit of discussions when you're discussing legal motion. For example, this house believes that the UN Security Council should veto power, United Security Council's veto power undermines international justice, or say the this house supports the jurisdiction of the International Criminal Court. So in international legal systems already, the ICC does not have jurisdiction all of the way unless you have signed on to the Rome Statute. Similarly, the UN Security Council veto power has often or not undermined a lot of international mechanisms which are used to address problems in international frameworks. So that can also be like a discussion point. So international law is essentially law which goes beyond the boundaries. So this is a very different concept from, say, sovereignty, which we were discussing, and this application becomes something like a very interesting point of discussing different types of legal motions, because international law is also part and parcel a way of like having like legal systems as well, because international law is also like a part of law. Now, the last thing here is that there might be certain constitutional issues which are like discussed. So constitutional issues have some sort of like intersectionality with procedural issues and say what we discussed previously in changing legal systems or reforming specific laws. So this can be something which is like intrinsic towards the constitution in and of itself, not just any law like associated around the legal framework. It can be something around the idea of how constitutional systems are working. Like this can be something which is very intrinsic towards how legal systems have been appended or utilized in a particular legal framework. Some examples of this can be this House supports term limits for Supreme Court justices, or this House would amend the Constitution to include a right to housing. All of these critically important issues, one dealing with, say, fundamental human rights of people or, say, positive rights of the individual in the second motion. First one, changing like a legal facet of how the Constitution's bedrock is requiring change because of, say, changing the system associated with it. Now, let's discuss some key considerations for legal motions. The first is that you have to think about what is the legislative intent or purpose of the law. So, what was like the original law trying to solve? What was the aim of the proposed change, and how is the law going to achieve the proposed change for the positive? So when you're giving impacts and frameworks of your argumentation, you have to be careful of addressing how this is something which is beneficial as an application towards the system, and like look at grounding your arguments on what the intent of the law was and how the law was supposed to operate or benefit certain individuals. Secondly, when you're looking at effectiveness and enforceability, you should look at how the law is currently working. So what is the current status quo? If there is an existing law, is it working better or is it working worse off? What are the problems it is facing? Are there barriers to its enforcement? So this would give you an idea about what kind of changes are required or what kind of systems need like addressal in terms of the conversation that are to be had when you're talking about, say, enforceability of the law and changing the enforceability of the law. So you can also like see that if you are actually proposing changes, is it going to help increase the effectiveness or enforceability, and what are the challenges that are going to be associated with it? So this helps you give like, and again, another impact analysis as to how your changes work, but also like a comparative case as to why it is better off from the existing systems or the status quo. The next thing that you probably need to look at is unintended consequences. So unintended consequences simply mean that there might be potential like side effects which might be like there when your application of law is there. For example, when you're giving the right to free speech, that also includes the problems of defamation and creation of other problems, right? When you're giving the right to have economic operation, there might be certain illicit activities are done, like black markets are created, or there are problems. So there might be discrimination which is happening. There might be systemic issues which might lead to, say, procedural delays, which means that due process is not followed well, and so on, right? So you have to always like also weigh your arguments better in terms of how the consequences of those potential like legal systems are, or proposed changes to the legal systems are. Now, some other considerations to be had then in terms of discussing these particular ambits. So, firstly, let's talk about access to justice. So, access to justice defines the idea that in the current law or legal system, is it ensuring to everyone that you have, regardless of status or resources that you have as an individual, can you access legal remedies and protections or not? So how would the proposed changes impact access to justice? How are you going to improve the method, or is your method actually going to like become a problem in terms of people accessing justice and other mechanisms around it? So these are the couple of things that you need to talk about when you're thinking about access to justice. We're going sort of speedily across these particular themes. There's also an unending amount of things to discuss, of course, when you're talking about these. Each of these can have like individual like sessions associated with it, but we are wanting to only give you an overview so that you have a basic bedrock or foundational understanding of legal principles and legal methods when you're doing, say, ambits around how law operates in and within and without the scope of the debate, right? So that is something that we are key focused upon. So pardon me if I'm going a bit faster across these topics. Now, talking about the second one, so there are balancing competing interests and rights. So of course, many legal debates involve clashes between like valid rights or legitimate interests. So there are people who have, say, different conversation points that is there. Some places where you might be discussing the victim's rights versus the accused rights. So um, innocent until proven guilty is a good example for that. There might be discussions around freedom of speech versus protection from hate speech, which was the example that I took previously as well. That, for example, if you're giving somebody the freedom to speak, you're also giving them the right to probably defame somebody or provide hate speech or other problematic content associated with those particular narratives. So it is very important for us to also consider how these proposed narratives are going to be changing the way in which access occurs in these particular narratives, but also how like access to justice is impacted, or how say other aspects are impacted and other things are impacted possibly. So how does the proposal navigate these tensions? Which principles should be prioritized and why, so on and so forth, is something that you need to discuss in terms of the way that you're operating. Next is, of course, when we talk about the four pillars of democracy, there is the main three pillars that come around for like discussion, because judiciary, legislature, and executive act as like a check and balance mechanism amongst each other, but also like act in terms of the requirements of how any administrative system and legal system and system of law in terms of the way in which the country is operating functions properly or not. So when you're doing say motions around law, you can take this like point of discussion where you take the idea of who is like better placed to make types of legal changes that you're trying to decide upon in the debate framework or discussing during the debate. Like, is it the legislature who should be making that change? Is it some change that you need to have in the judiciary? Is the executive the one that you're trying to address, and so on and so forth? You need to sort of like analyze and discuss which part and parcel of these particular discussions are going to be helpful or interpretative. Now, of course, courts interpreting law versus parliaments creating law is another debate in and of itself. Like, do you want the law to come around from, say, the courts interpreting the law differently? Or is it like something which needs a complete, like, new law to be passed, or parliament amending certain existing laws to better suit the needs of, say, the framework of how it is right now? Now, there are certain concerns and things that you need to look at when there are certain like problems when the executive doesn't need let the legislature or the judiciary function properly. When judiciary sometimes have judicial activists, which means that judiciary oversteps its bounds and takes in certain considerations, which is usually under the domain of the legislature or the executive, and gives decisions around it. Or have like some in some cases there might be legislature overreaching as well, and not allowing the executive to work or the judiciary to work by passing very like problematic legal spheres and other problems which are associated with the systems. So when you're analyzing these ideas, try to like take into account the interests, effects, challenges, needs, and requirements of these three systems. Like, what does the judiciary need and what does the judiciary intend? What does the legislature need? What does the legislature intend? What does the executive need? What does the executive intend? And what ambit under which these three operate, and where those checks and balances are occurring. So all of these will give you an idea about how to frame your argument better in that space, and give you sort of like a principled understanding as to where to make changes or not make changes, or what essential problems that you want to deal with or not deal with. Now, let's give you like a framework for analyzing legal motions as well. So the first thing that you would want to do is identify the problem. So what is the current problem with the existing legal system or status quo? What kind of like narrative exists? What kind of like principal harms exist? What kind of procedural harms exist? Why is it something which is required to change? Why is it something which is like inherently problematic as it exists today? Secondly, what you would want to do after identifying the problem is explain the mechanism as to how the proposed change that you're trying to make after identifying it is supposed to operate. So you also need to tie it back into, say, the problem statement itself. So, for example, if you analyze that there's a problem which is there in terms of the application of the law, you have to also like sort of like give the idea as to why you are trying to make that change, and also like why your proposed change solves the problem to begin with. So the second step becomes a very important consideration for you. Thirdly, you would want to analyze outcomes. So, what are the direct legal effects of taking, say, certain steps? What are the broader societal consequences, intended or unintended or otherwise? How does it impact rights, justices, rules of law, etc., etc.? So, what you mean by analyzing outcomes is when you're giving a proposed mechanism change, you can't always probably deal with all of the things in a positive light. There might be certain counterbalances which you are trying to operate within. So there might be certain amount of positives, certain amount of negatives in the newly proposed legal systems. You need to show why your proposed legal system is overall or overarchingly going to be better off than, say, worse off in terms of how you're trying to go ahead and achieve certain impacts or certain requirements. So a motion will give you a certain burden to deal with. So your outcomes should analyze those particular burdens, and the burden of proof should be something that you need to like prove in terms of proposed outcome that you are in terms of having the mechanisms apply towards the change that you're trying to build, right? So this can simply sound like consequential things. For example, if the problem statement or the burden of proof dictates that you need certain amount of change in the legal status quo to improve the access to justice, your outcome should always be analyzed towards the access of justice impact that your proposed mechanism has. So you have to be very careful when you're addressing these issues or these statements, that you build it out in a way in which it is much more charitable towards understanding what the required nuances are, or what the essential requirements are within the framework of the debate, and proceed so on. So that is the thing that you need to do. But there is also a couple of things that you will, of course, do better through practice. So there might be certain things that you need to practice more, and then that will be something which will help you over a period of time. So the last couple of things that we'll be discussing is some key takeaways of interpreting legal language and burdens. So firstly, you have to be very careful about minding legal terms. Things like legalize, decriminalize, and regulate sound probably very similar to people who are not very attuned towards legal jargon, but each term has some sort of like very associated, some associated value and some associated like utility in terms of how they're operating, right? So legalize could mean that you are making something that was unlawful before lawful, which often implies that there is a new regulation that might come into, say, effect, and a new law that might come into effect. Decriminalize, on the other hand, means to remove criminal penalties for an act through civil penalties or regulations that might still apply. So it's not necessarily legal, but it might be something like a reduction of penalties or a reduction of possible harms, or possible like punishment systems that are there. To regulate means to control or supervise by means of rules and regulations. So you have to be like particular about what the motion requires you to do. Some motions might require you to change the legal system. Some motions might require you to decriminalize certain things. Some motions might require you to regulate certain things better. So be careful as to addressing what you're trying to achieve and what you're trying to do. Be clear on what the burden of the motion is and which actual system that you're trying to do. Are you trying to regulate, decriminalize, or legalize? So if unsure, try to be as reasonable or charitable in your definition when you're trying to build out from the first speech in and of itself. Secondly, when you're talking about specific legal jargon, so if a motion uses terms like mens rea, strict liability, ultra vires, a brief and clear explanation might be needed of understanding what's centrally there. Sometimes some motions do have context rights. So focus on directly what the implication is of this specific legal term on the debate. So, for example, what does mens rea do in terms of the way in which people are operating or people are judged in terms of a criminal trial? Think about how strict liability is different and think about how strict liability applies in legal frameworks. Why is it something which is necessary? Why is it something which is not like removable from a legal system, so on and so forth? So these implications that these have within the debate systems will give you an idea about how to do the debate and how to like adjudicate certain claims and analyze certain things around the debate fruitfully. Next, we have discussed this a bit, but each debate around, say, law would have certain burdens which are associated with it. So you have to be careful that you do not go beyond, say, what are the burdens which are required within your motion. So proposing a change to law might sometimes mean that you might be proposing a significant flaw in the status quo, and that the benefits of the change might sometimes outweigh harms, which is why you're making the proposed change. So you can't always have like a perfect law where everything that you're doing is willy-nilly going to be good. So you have to be careful in terms of balancing the ideas that you're trying to propose and showcase why the benefits that you're trying to propose are higher than the harms that might come around from the proposed change. So there are certain things that you have to be careful about in a debate space. So, for example, when you're restricting established rights, typically it carries a higher burden of proof. For example, like showing a compelling state interest and that the restriction is narrowly tailored and proportionate. So, the more that you restrict yourself on a narrow spectrum, the more likely it is that you're benefiting through impacts a very small degree of people in, say, the framework of law or where the law is operating. And there's a higher likelihood that a lot more people will have like problems with those systems, which might mean that those impacts are not justified for making those changes or proposed changes. Now, also when you're like, say, for example, talking about restricting the freedom of speech, so there might be a higher burden of proof that you're trying to take around because freedom of speech does do a lot. So if you're going to like ban the freedom of speech completely, it's much more problematic for you to defend your stance because there might be a lot of problem when you are trying to go against established rights and principles which are there, because a lot of people do have ideas around how these principles and rights operate, but also on, say, how these are principally supposed to be and how they're going to benefit or not benefit. So you have to be very careful in the way in which things are going to be like spaced and things are going to be considered. Now, the last thing you have to consider who bears the onus of proof and what level of certainty is required. So, do you need to prove something? Or do you need to prove the harms that the other side mechanism has? Do you need to provide the impacts of your mechanism? You have to be careful of understanding and addressing those particular factors and sort of bringing that around in terms of the debate that you're trying to done. So that more or less ends the part of the debate where we are talking about, say, law in and for debates. I hope that overview sort of helped you. Couple of things to end off in terms of researching and reading for law. You can read legal principles through things like statutes. For an average reasonable voter, also, there might be certain requirements for you to at least be aware about legal concepts. So try to take around, say, time to have like a researching or a reading framework associated with your like studies for, say, any subject matter. For instance, if you're trying to talk about specific themes, try to like go in depth and in terms of general debate feedback, also in terms of general advice to debaters, it's better that you sort of have an idea about what you're speaking about. So therefore, have extensive amount of time that you spend reading and researching about law. Key takeaways from today's session. You have to be very careful when you're applying legal principles. Legal principles are very structured and nuanced in certain cases, but sometimes also very ambiguous. So you have to be very careful that you're going to be debating on the ambit of impacts and the ambit of what is required or what is necessary for you to do. And therefore, you have to sort of like think about principle nuances. You need to think about legal concepts and jargons as they're operating and what kind of necessities they're operating within and what kind of externalities and problems that they have as well. The other thing that we'll sort of like give you as a key takeaway is that the idea about how, say, the principle, you have to be very careful when you're taking on burdens in terms of a debate space for legal debates. Be very careful that you're addressing your burdens properly in the debate paradigm, but also that you're impacting properly and weighing properly and providing the comparative properly so that your debate paradigm is not something which is negated or not something which is like in a problematic spectrum and is having certain problems in terms of its addressal and issues. So also be careful about how you are talking about different things within legal paradigms. Not all law applies to all situations. Not all principles can justifiably deal with all probable cases. So you have to be careful that you're applying the right principle or the like legal concept to the right like situation and analyzing them thoroughly. Be sure that you are not like skipping the part of analysis or weighing, because you can't really like I've seen this happen in a lot of debate spaces where people are debating on a parallel level or maybe debating on their own street and not really discussing matters that are important in terms of how you are going to win the debate by showcasing why you want a comparative or better or why your impacts are something which are a priori good or maybe say a priori as in on the onset very good or maybe say something which is much more viable or long term is going to be beneficial or something which is going to address the situation in a better manner. So you have to be careful in doing that, right? That you have to be very careful in addressing typical lacunas and typical like problems that might come around, and that be ensure that your argumentation is robust and there's no problems associated with your argumentation. But anyways, those are the key things as takeaways. I'll just pause a bit for questions right now, and then I can just give you a concluding remark before we end wrap up. Okay, I see a question on the chat. There is a question which has been asked that if you are not aware about legal concepts and if you're not aware about how to apply those legal concepts, how can you still debate, say, legal frameworks and legal principles? The best way that I can answer this for you is simply that probably you have a lot of like ways in which you can utilize common sense or like basic understanding of what is right or wrong in terms of legal fabrics. So that can help you build certain amount of consciously impacts in terms of debate. But also like don't think of it like a legal principle or concept when you're reading the motion. Think of it as what is the intended consequence of the motion or what is the intended like end you're trying to reach. Now, after that, you can think about pathways to that end, which will help you like decide what are the right approaches, what are the right changes, or what are the right system that you're going to like utilize in terms of reaching that particular method or particular benefit. And that will help you do things a lot more easily when you're doing the ideation around it and you're doing the discussions around how you're approaching this, even when you're not aware probably of legal situations, so on and so forth, that extensively. Um, right. So I don't see any other questions on the chart. And it's been quite a while since we started this session. So let's just quickly move on towards the end as well. Thank you everybody for joining in. Hope to see you all again soon in another of the workshops that we'll be holding regularly. Thank you all for joining in. Take care. Have a great evening. Bye bye.